CAA number 3, A Historical Timeline by Kevin McConney. In the Gwing-Hee Lee v. Johnson & Johnson v. San Francisco Unified School District, Chinese Americans fought desegregation orders that would force students out of neighborhood schools. The courts ruled against Chinese, saying that the Brown case applies to race. Despite significant progress in the half-century since Brown, the practice of segregation in public schools remains widespread. School districts that provide bilingual education and ESL programs constantly struggle to balance the needs for separate classes where the unique needs of ELL students can be addressed against the needs to avoid prolonged segregation of ELLs from other students. In the Myers v. Nebraska case, states ruled that the act could not prevent schools from teaching German outside of school. While the government can regulate language in school, they could not regulate it outside. Schools taught German outside of school as an extended recess program. In a major victory for language minority parents and communities, the Supreme Court struck down the state's restrictive legislation, ruling, in essence, that whereas states' government can legislate the language used for instructions in schools, states may not pass laws that attempt to prevent communities from offering private language classes outside of the regular school system. Myers is an important case because it makes clear that the 14th Amendment provides protection for language minorities. In the Farrington v. Toshiga case, further protection for after schools were created. These cases were essentially about parents' rights rather than language rights. In addition, within the court's decisions, there were still signs of negative attitudes towards the foreign population. Indeed, Hawaii tried again to limit private foreign language instructions. When the Chinese communities after World War II sought to restart their private language schools, the states passed the act regulating the teaching of foreign language to children. In the Lau v. Nicholas case, in 1974, the Supreme Court made its most important decision regarding the education of language minority students. This case was brought forward by Chinese American students in the San Francisco Unified School District who were placed in mainstream classrooms despite their lack of proficiency in English and left to sink or swim. The district had argued that it had done nothing wrong and that the Chinese American students receiving treatments equal to that of the other students. Under these state-imposed standards, there is no equality of treatment merely by providing students with the same facilities, textbook, teachers, and curriculum. For students who do not understand English are effectively foreclosed from any meaningful education. We know now that those who do not understand English are certain to find their classroom experience wholly incomprehensible and in no way meaningful. After the court's decision, the U.S. Department of Education's Office of Civil Rights created the Lau Remedies. The Lau Remedies applied to all school districts and functioned as de facto compliance standards. The Office of Civil Rights used the Lau decision to go after districts that, like San Francisco, were essentially ignoring the needs of its ELLP students. Lau Remedies essentially require districts to implement bilingual education programs for LEP students. The Lau Remedies specified proper approaches, methods, and procedures for identifying and evaluating national origin minority students, English language skills determining appropriate instructional treatment, deciding when LEP students were ready for mainstream classes, and determining the professional standards to be met by the teachers of language minority children. The essence of Lau was codified into federal law. In the United States versus Texas case, It was mandated in all Texas schools. The courts ordered the districts to create a plan and implement language programs that would help Mexican American students learn English and adjust to American culture, and also help Anglo students learn Spanish. The court relied heavily on the testimony of Jose Cardenas and his theory of incompatibilities, which blames the educational failure of students on the inadequacy of the school programs rather than the students themselves. In the Cerna versus Portales case, this was the first case to raise the issue of bilingual education outside of the context of desegregation. The case dealt with a white majority school in New Mexico that failed to meet the unique needs of Spanish surnamed students. The judge declared it is incumbent on the school's district to reassess and enlarge its programs directed to the specialized needs of Spanish surnamed students, and to create bilingual programs at other schools where they are needed. This case was first decided in 1972, and later it was appealed to the 10th Circuit Court of Appeals, and decided in 1974, just 6 months after Lau. Like Lau, it makes clear that schools cannot ignore the unique language and education of ELL students. Rios versus Reed. This case claimed that many so-called bilingual education programs were not bilingual, but based mainly on ESL. The federal court found the district's bilingual programs to be woefully inadequate, pointing to the lack of trained bilingual teachers and the absence of a clearly defined curriculum. Although the courts issued no specific remedies, the Federal Office of Civil Rights came in to ensure the districts made improvements. This case is significant because it made a strong case for offering bilingual educations and for doing it right. In the Equal Educational Opportunities Acts of 1974, or EEOA, no state shall deny educational opportunities to an individual on account of his or her race, color, sex, or national origin. The failure of an educational agency to take appropriate action to overcome language barriers that impede equal participation by its students in its instructional programs. The Supreme Court never did mandate bilingual education. The EEO remains in effect, and several subsequent lawsuits have been based on this important legislation. The Castaneda Standards. These standards mandates that programs for language minority students must be based on a sound educational theory. The Castaneda Standards, which encapsulate the central features of Lau. However, the shortcomings of the Castaneda test, referring to the prongs 1 and 2, notes that nearly any program can be justified by an educational theory, and that some approaches require very little in the way of staff or funding. A certain amount of time must pass before a determination can be made about the adequacy of the programs. Thus, many students may be harmed in the inadequate programs are identified and rectified. Work cited, Wright, W.E. 2010, Foundations for Teaching English Language Learners, Research Theories, Policies, and Practice, Experts from Chapter 3. Cardeas, J.A., and Cardeas, B., The Theory of Incompatibilities. Delval, S., 2003, Language Rights and the Laws in the United States, Finding Our Voice. Causal, J., The Shame of the Nation, The Restoration of Aprethied Schooling in America. Leon's 1995, The Past and Future Direction of Federal Bilingual Education Policy. Tamra, The English-Only Efforts. Tesla, Teachers of English Speakers of Other Language. Trujillo, Latino Civil Rights Movement. The U.S. Department of Education. Willie T.J., The Imposition of World War I Era English-Only Policies. This has been CAA number 3. I hope you have learned about many of the cases and laws that have got our ELL and ESL programs to what they are today. Thank you very much for listening, and have a good day.